Welcome to this in-depth explainer. First, we will clarify why a visa status marked refused is rarely just administrative processing. Next, we will unpack expedited removal, the 5-year bar, and the permanent bar tied to fraud or willful misrepresentation. Then, we will decode how 221G differs from a final refusal and what the waiver process really requires. Finally, we will walk through a realistic action plan and conclude with key takeaways. Let's begin. Here is our roadmap. First, we will define what a refusal is and is not. Second, we will explain expedited removal and the 5-year bar. Third, we will explore fraud findings and the permanent bar. Fourth, we will compare 221G administrative processing with a legal refusal. Fifth, we will outline the waiver landscape, including I-212 and I-601. Sixth, we will detail a step-by-step action plan and essential documents. Finally, we will test comprehension with a brief quiz. Before we proceed, please note this is general information for educational purposes. It is not legal advice. Laws and policies change, and outcomes depend on specific facts. Therefore, you should consult a qualified immigration attorney for personalized guidance. When your case shows a status of refused and includes a citation of a statute such as 212A9A(I) or 212A6(c)(I), the officer has made a finding of inadmissibility. This is not the same as ongoing administrative processing. In effect, the refusal stands until the legal barrier is removed through the appropriate process, often a waiver. This distinction is crucial. Let's compare. Administrative processing under 221G typically means the consulate needs more documents or must complete background checks. By contrast, a final refusal that cites an inadmissibility statute indicates a legal barrier to issuance. If the refusal letter leaves waiver checkboxes blank, it often means no waiver has been recommended and the case is effectively paused. At that point, the burden shifts to the applicant to address the inadmissibility through evidence and, where appropriate, waivers. This sequence diagram shows the life cycle from an attempted entry to final visa decision. First, the applicant may encounter Customs and Border Protection. If expedited removal is issued, that event triggers a statutory bar. Later, at the consulate, the officer assesses admissibility. If inadmissibility is found, the officer may signal that a waiver is required. Next, with legal counsel, the applicant can file the appropriate waivers. The I-212 is for permission to reapply after certain removals. The I-601 addresses grounds like fraud or willful misrepresentation. USCIS adjudicates these applications and sends results back to the consulate, which then makes the final visa determination. Expedited removal is an immediate action at the border that triggers a 5-year bar under 212A9A. Attempting to apply for any visa shortly after this event is generally ineffective unless the bar is addressed. In practice, this often means filing an I-212 application for permission to reapply before seeking a visa. Importantly, you should not assume that the government will initiate a waiver on your behalf. Instead, proactively pursue the correct waiver sequence with legal guidance. A finding of fraud or willful misrepresentation under 212A6(c)(I) results in permanent inadmissibility. This bar does not expire with time, so even after 5 years, the person remains inadmissible unless a waiver is granted. The I-601 waiver typically requires demonstrating extreme hardship to a qualifying U.S. relative, such as a U.S. citizen or lawful permanent resident spouse or parent. Sometimes, facts such as prior employment linked to a problematic entity can lead to such a finding. Therefore, a thorough factual analysis and evidence strategy are essential. This table contrasts two common bars. The 5-year bar under 212A9A(I) arises from expedited removal and typically requires an I-212 application to overcome. The fraud or willful misrepresentation bar under 212A6(c) is permanent until waived and normally requires an I-601 showing extreme hardship to a qualifying relative. If both issues exist, an applicant may need both I-212 and I-601. On the left, 221G denotes administrative processing. This typically means additional checks or documents, and no statute of inadmissibility is cited. The case remains pending, and could later be issued or denied. On the right, a refusal that cites an INA statute signals a legal inadmissibility determination. The case is effectively closed or suspended. Waivers are not started automatically. The burden falls on the applicant to pursue the correct waiver strategy. Here is a structured approach. First, stop repeatedly reapplying and step back to assess. Second, obtain records through FOIA, including CBP records, consular notes, and any I-213 or related documentation. Third, engage a specialized immigration attorney. Fourth, identify the exact statute cited. Fifth, select the correct waiver path. I-212 for permission to reapply after removal. I-601 for fraud or misrepresentation, or both if needed. Sixth, if filing I-601, document the qualifying relationship and compile evidence of extreme hardship. Seventh, prepare strong equities, such as rehabilitation and community ties. Eighth, be strategic about timing. Time alone does not cure fraud findings. Ninth, avoid risky travel or ESTA attempts while inadmissible. 10th, organize and retain all records and correspondence. Quiz time. The question asks what a rapid change to refuse status with a citation to 212A(6)(c) indicates. Options: A. Routine administrative processing. B. A final legal finding of inadmissibility for fraud or misrepresentation. C. A temporary hold that will clear after 30 days. Or D. Approval pending a supervisor signature. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. A refusal that cites section 212A(6)(c) indicates a legal finding of inadmissibility for fraud or willful misrepresentation. This is not routine administrative processing. Second quiz. The question asks which bar an expedited removal triggers under section 212A(9)(a). I. Options are a 1-year, 3-year, 5-year, or permanent bar. You may pause the video now to consider. We will discuss the answer in the next section of the video. The correct answer is C. Expedited removal triggers a 5-year bar under 212A(9)(a). I. Overcoming it commonly requires permission to reapply via I-212 before a visa can be issued. These are the core points. A refusal with a statute is a legal inadmissibility decision. Expedited removal triggers a 5-year bar. And fraud findings create a permanent bar. Waivers are not automatic. The applicant must initiate them. The I-601 typically requires demonstrating extreme hardship to a qualifying relative. Early legal consultation and comprehensive documentation are essential. To conclude, do not confuse 221G with a refusal based on a cited statute. Identify the exact grounds of inadmissibility, then build a waiver plan. Typically, I-212 addresses removal bars, and I-601 addresses fraud or misrepresentation. Work closely with a qualified attorney, collect comprehensive records, and construct persuasive evidence of hardship and equities. Patience and strategy are vital. Thank you for watching. If you found this valuable, please like, share, and subscribe. Finally, tell us your biggest remaining question in the comments so we can address it in future videos.